Hello, welcome. We'll give it a couple minutes for people to get the notification and come in. So there's been a lot of activity in the Morphew case lately. Yesterday, Linda Stanley. I'll wait a couple minutes before I say this. It's not that important, but you know what? I bet people will want to hear it. So I'll wait. The kids been on spring break. I've been super busy. Whew. Try to fit everything I had to count. Every little bit of time I have to go live, but I had to go live about this. Hey Gladys, I had to go live about this because Morphew's my favorite case. So, what's up, girl? So yesterday, Linda Stanley. All right. So in a nutshell, the judge. I got to start from a little bit back, so you guys. You just got off work. Oh, good. Well, then you can sit and listen to it. Hey, thumbs up. So I'm going to go back a little bit, even though I explained this before, but I feel like it's just so people know. The past couple court hearings, the judge has made so the prosecution wanted all these expert witnesses to come in and testify about certain things. There's like a canine handler. Hey, Canis. There's a canine handler. There was a veterinarian who knows a lot about tranquilizer guns, or not guns, but like the solution. She even has like a patent on it. There was a couple people with the truck telematics, the phone guys, things like that. So the judge pretty much deemed a lot of they're not able to testify as experts, but they can still testify. So the reason why some of them can't testify as experts, for example, the canine handler, they didn't get his report in time for the defense to make an argument about it. And then the veterinarian, she's not versed on. Actually, they might still be making a decision about a veterinarian, but they're having another hearing where they'll decide if I think it's a veterinarian and the lady who does she's a nurse and she looks at Barry's photos of the scratches on his arm. Well, they're arguing that the nurse isn't an expert at diagnosing through pictures, and that the lady with the tranquilizer dart, that she doesn't. There's no studies on how the tranquilizer would affect humans. There's only studies on animals, and she is well versed on animals, but she doesn't know how it would affect humans. So things like that. So basically, 13 out of 16 of them cannot testify as experts, but they can still testify. So, Linda Stanley yesterday, I believe it was, it just came out yesterday. She filed a motion to reconsider. So she asked, please consider these. We need them to explain this and that, or whatever. And then the defense, sorry, I was scratching my throat, it's bothering me. Then the defense filed and said, no, all right. So Linda said, we gave you all this stuff. You have it. We should still be able to go through. She's pretty much arguing all her points. And the defense put out one arguing back to points. So then the judge finally put one out, just answering the prosecution, answering the defense, and answering the question if it's going to trial or not, which we've all been waiting for. So let me share my screen real quick, and I will show you guys. I can zoom in a little. Let me take a sip of water. Sorry. So I'll go over this real quick. So this is basically, this is all like first paragraph is just him saying that he looked at all these exhibits and went over all the testimony and things like that. And that's how he came to, the court has reviewed all the briefing, testimonies, exhibit, the case file, and the pertinent law. Being fully advised, the court finds, concludes, and orders as follows. So they give a little summary. Suzanne of Mayfield, Colorado went missing on or about May 9th to 10th, 2020. Initially, a neighbor raised concerns when he was unable to locate her. The neighbor contacted husband, Barry Morphew, as well as the authorities. Mr. Morphew owns a landscaping business and was in Denver area working on a project when he received the phone call. Shortly after the phone call to law enforcement, sorry, I was reading the chat. Yeah, I will update you with all the latest Morphew stuff because I've been following it, KNS. If it doesn't go over everything at the end of this, I'll go back a little bit so you understand a little bit more of how it got here. Where were we? Shortly after the call to law enforcement, police found Mrs. Morphew's bike off a dirt road down a ravine near her home. The bike appeared to have been crashed or been strategically placed in that location. Apart from her bike, there was no sign of Mrs. Morphew. More search and rescue personnel were brought in to assist that evening, but she was never found. A massive search involving numerous law enforcement entities and volunteer community members from nearby Salida ensued. An individual did find Mrs. Morphew's bike helmet west of her bike off of Highway 50. However, Mrs. Morphew was never located. To date, she has never been found. After failing to find Mrs. Morphew, law enforcement suspected foul play. In addition to continuing their search for Miss Morphew, police were actively investigating her disappearance as a potential crime. The Morphew residence, including vehicles, were searched and numerous items of evidentiary value were collected. The police, among other efforts, obtained DNA samples from the scene, including from the bike helmet, and Mrs. Morphew's vehicle. Mr. Morphew soon became the focal point of law enforcement's investigation. Police searched the contents of his phone, including location data. Data on Mr. Morphew's phone indicated that around the time she went missing, he turned left on Highway 50 west, passing the location where Mrs. Morphew's bike helmet was found on the side of the road before ultimately turning around to head to Denver for work. Mr. Morphew said he was following an elk and turned around near Garfield, a small community about 3 to 4 miles west of where Mrs. Morphew's bike was found. That and other location data on his phone raised suspicion among investigators. Mr. Morphew also spoke with police on numerous occasions. While he never admitted to any wrongdoing, police had come to suspect his involvement in his wife's disappearance. In the summer of 2020, CBI forensic analysis determined foreign unknown male DNA was found on various items of the crime scene. The interior cushion of the bike helmet, Mrs. Morphew's bike, the glove box, and back seat of Mrs. Morphew's Range Rover. Mr. Morphew, along with other investigative personnel working on the scene, were excluded as the source of the sample. CBI agent Joe Cahill was lead investigator assigned to assist local authorities, Chaffee County Sheriff's Office in parentheses, in the investigation of Mrs. Morphew's disappearance. Communication logs with Forensic Laboratory Division of CBI indicated that Agent Cahill had come to believe the DNA sample found in Mrs. Morphew's car belonged to suspects who may have perpetrated the crime. In turn, CBI analysts determined the partial genetic profile combined with the investigation warranted uploading the sample to CODIS, a nationwide DNA database. CODIS is an acronym for Combined DNA Index System and the generic term used to describe the FBI's program of support for criminal justice DNA databases, as well as the software used to run these databases. CODIS contains DNA samples of convicted offenders nationwide, along with unknown samples from unsolved crimes and active investigations. On May 19th, 2021, Agent Cahill, among other law enforcement personnel, received a CODIS match letter indicating the unknown male DNA partially matched DNA found in 3 out-of-state unsolved sexual assault investigations: Tempe, Phoenix, and Chicago. The letter further indicated that due to the limited genetic profile, this was only a lead, and further investigation was necessary. So basically, they got it like a partial hit, and they looked further into it. There were suspects, but they said eventually these were ruled out. But also, there's been a DNA CODIS hit that they got from like Maryland, I think it was, either Michigan or Maryland, that they haven't really talked about that much. But there was another hit that CBI said they left it unresolved. That was the word they used. Sometime in late April of 2021, CBI detectives working on the case became aware that Chaffee County Sheriff's Office was going to arrest Barry Morphew, charging him with the murder. Agents Cahill and Graham strongly opposed the arrest of Barry Morphew, citing the need for more forensic testing and evidence collection in general. They also wanted to look more into his financials, and sorry if you guys can. They also wanted to look more into his financials, and since they had him talking, they wanted to keep him talking too, and they really felt that it was too early to arrest Barry, to the point where the head of CBI said that it was the first time he ever called a sheriff and literally begged him not to make the arrest. But they made the arrest anyway, which I think was because Linda Stanley told, wanted to make a show out of it a year after she was missing and arrest Barry. Conveniently, the YouTubers knew about it, and Dateline just happened to be there. So anyway, they both believe the arrest was premature, and they raised concerns with Kirby Lewis, head of Major Crimes Division of CBI, who in turn brought those concerns to Deputy Director Chris Schaefer. Mr. Schaefer called the Chaffee County Sheriff, John Speasy, and advised against arresting Mr. Morphew at the time. He expressed the concerns of Agent Cahill and Graham, and it was the first time in the deputy director's career that he ever called a sheriff about holding off on the decision to arrest. Oh yeah, super convenient film though. Holding off on the decision to arrest an individual. Shortly thereafter, CBI Director John Camper called the sheriff and reiterated the Bureau's concerns with arresting Barry Morphew. So basically, CBI did not want them to do this. They said it was premature, but they did it anyway. On May 4th, Alex Walker authored a 129-page affidavit in support of the arrest of Barry Morphew on suspicion of homicide, along with other charges. The affidavit states numerous agents from CBI reviewed and edited the affidavit, but failed to state that the Bureau did not support the arrest of Mr. Morphew. Notably, as of May 4th, 2021, law enforcement had still not determined the source of the unknown male DNA found throughout the crime scene. The affidavit failed to inform the judge of said DNA and that Barry Morphew was excluded as the source. Ultimately, Chief Judge Murphy found probable cause and set a no-bond hold as requested by the affidavit. Chaffee County Sheriff's Office arrested Mr. Morphew on May 5th, 2021. Oh, hey, Sarah. Sorry, the chat got a little ahead of itself and I didn't see you there. In months leading up, oh wait, no, I skipped a paragraph. On May 19th, the people disclosed a CODIS match letter to the defense indicating the unknown source of DNA may be linked to other unsolved out-of-state sexual assaults in Tempe, Phoenix, and Chicago. Meanwhile, Mr. Morphew remained in custody, unable to post bond, pending his preliminary hearing and his hearing to determine whether the proof was evident and presumption great. Example, a bond hearing reserved for those accused of first-degree murder. In the months leading up to and during the preliminary hearing, the prosecution had 3 meetings with law enforcement and CBI analysts to discuss the meaning of the CODIS match, its significance, and follow-up investigation to rule out potential sources of the DNA. Information tending to negate the guilt of the accused was discussed, but nothing was reduced to writing and disclosed to the defense in any of the 3 meetings. The preliminary hearing commenced on August 9, 2021, and lasted 4 days. The people called the following witnesses: Alex Walker, Kenneth Harris, Jonathan Grusing, Derek Graham, Andy Rorick, and Kevin Kovac. The people did not elicit any testimony concerning the foreign male DNA from any of these witnesses. The defense ultimately called Agent Cahill of CBI to present the information to the court. The court reserved ruling. On September 17, 2021, the court issued its ruling to find that proof was not evident and the presumption not great. The court specifically found that the unknown male DNA profile was particularly significant because while it doesn't prove a stranger abduction theory, it does at least support it. Accordingly, bond was set, which the defendant posted. In all, the defendant remained in custody, unable to post bond for a little over 5 months. The defendant is charged with first-degree murder along with other counts for the alleged murder of his wife, Suzanne Morphew, on or about May 9th or 10th, 2020. Defendant has pled not guilty, and a jury trial is scheduled to commence on April 28th. 20 more days. It's like so soon. I wish we were allowed to watch it, but we're not. So we're going to be waiting for all the details at the end of every day. So, the purpose of CR 16, which sets forth pretrial disclosure obligations of the prosecution and defendant, is intended to ensure a fair trial by permitting both sides to obtain relevant information before trial, thus reducing the risk of trial by ambush. So basically, any evidence that the prosecution has that could be, well, anything really that they have, or anything that could be favorable to Barry Morphew needs to be handed over in a discovery, and they need to know what witnesses they're calling up, what they're going to talk about, all that stuff, so the defense can properly prepare and prepare their cross-examinations, all that stuff. And in a nutshell, I'm assuming because they weren't ready to arrest them in the first place, they are super behind and they are not handing things in on time. Some of the stuff they're like 8 months late to handing stuff in. It's terrible. But Rule 16 IA2 requires the prosecuting attorney to disclose to the defense any material or information within his or her possession or control which tends to negate the guilt of the accused as to the offense charged or would tend to reduce the punishment therefore. Specifically, the prosecution must disclose exculpatory evidence to the defense, meaning evidence that is material. Evidence is material only if there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome. Exculpatory evidence includes evidence which bears on the credibility of a witness the prosecution intends to call a trial. I think he's saying that because Joe Cahill, he was the lead investigator for CBI when they went to the preliminary hearing. Sorry if my husband's gaming, so if you can hear him in the background, I apologize. But I can hear him talking, so I'm just letting you guys know. But anyway, Joe Cahill, he went to the preliminary hearing. He was like unprepared, and they asked him questions, and he didn't. He said that there wasn't what do you call it, suspects, stuff like that, and there was. So they said that he was withholding exculpatory evidence, which he wasn't. He was just unprepared and he didn't know. But it was really interesting because as a lead investigator, he overlooked like a bunch of emails. He didn't read all the reports. He didn't read all of the reports in full. Like it was just they weren't, like I said, they weren't prepared. Well, after he testified, Linda Stanley told him to hit the road because she was not pleased with how he testified, and she sent him to the marijuana crimes unit. Then a couple months later, he shoots himself in the hand with his service weapon at home, and when he gets investigated by Internal Affairs, they question him. And he lies to them several times about what went on. I don't know how they could tell he lied or not, but apparently he lied. And that puts them on something called a Brady list, which is a list they send out to defense or prosecutions that are using him in testimony and stuff like that. And letting them know that he may not be credible because he lied. So he's on a Brady list, and while he's being investigated by Internal Affairs, they do an interview with him. And during the interview, he says them arresting Barry Morphew was the stupidest thing they could have ever done, and like goes on about it. So that's how they came to that point where CBI would when they found out that he said that, the defense subpoenaed all the people from CBI plus Linda Stanley and made them testify, and they all admitted that they had tried to stop the arrest of Barry Morphew, but they went on with it anyway. Linda Stanley was also held in contempt at one point because she went on Profiling Evil and did an interview about the case when she was on a gag order. And even though she didn't technically give like a lot of detail about the case, the defense argued that her going on Profiling Evil, like set a precedent that Barry's evil because the show's called Profiling Evil and it's tainting a jury. So she was held in contempt of court. She hasn't showed up for court in who knows how long, besides when she was subpoenaed. Which I find really funny because she did an interview during the election before she got elected. And they asked her, what do you think about like large cases and like the DA's role in them? And she said that the DA should be present in court for major controversial cases. And she just has not been present at all. So there's that. All right, where was I? Let me get back to where it was. The prosecuting attorney's obligation under Section A extend to material and information in the possession or control of members of his or her staff and of any others who have participated in the investigation or evaluation of the case and who either regularly report or with reference to the particular case have reported to his or her office. The prosecuting attorney shall perform its obligations as soon as practicable, but not later than 35 days before trial. It is the prosecuting attorney's duty to ensure that a flow of information is maintained between the various investigative personnel and his or her office sufficient to place within his or her possession or control all material and information relevant to the accused and the offense charged. They haven't really been maintaining, what would you call, like, a nice little flow with them. They've been not answering emails and not sending stuff over. They've been very difficult. And I don't know if it's they're purposely trying to, like, withhold the evidence as long as they can so they can't prepare, or if it's because they're just very unprepared. When it is brought to the attention of the court that a party has failed to comply with the Rule 16 or with an order issued pursuant to Rule 16, the court may order such party to permit the discovery or inspection of the materials not previously disclosed. 2. Grant a continuance. 3. Prohibit the party from introducing it as evidence, the material not disclosed. Or 4. Enter such order as it deems just under the circumstances. Discovery sanctions serve the dual purpose of protecting the integrity of the truth-finding process and deterring prosecutorial misconduct. Oh, that's a tongue twister. A district court should account for these purposes by imposing the least severe sanction that will ensure full compliance with the court's discovery orders and protect the defendant's rights to due process. Or what's that? Okay. Dismissal is a drastic sanction and must be reversed for situations where no other sanction will. Restore as nearly as possible the level playing field that existed before the discovery violation. So it's actually really uncommon for a judge to dismiss a case, or like you want to go with the smallest penalty that you can to make them comply, is what they're saying. In the absence of willful misconduct, which obviously it means like they're purposely doing things to screw it up, dismissal as a sanction for a discovery violation is usually beyond the discretion of the trial court. In the absence of willful misconduct or a pattern of neglect demonstrating a need for modification of a party's discovery practices, the rationale for a deterrent sanction loses much of its force. Particularly in the criminal justice context, the need to find the truth is the paramount interest at stake. The regulation of discovery matters lies within the sound of discretion of the trial court. Because of the multiplicity of considerations involved in the uniqueness of each case, great deference is owed to trial courts in this regard, and therefore an order imposing a discovery sanction will not be disturbed on appeal unless it is manifestly arbitrary, unreasonable, or unfair. Let me look. Can we overlook this real quick to see if I need to read all this? Okay. So this is just like a timeline of the stuff they did, like the filing charges. In court, the lead district attorney, Jeff Lindsay, objected to D13 paragraph 2, emails and text messages, as it was overly burdensome to the prosecution. So he's basically saying they were having a hard time handing over all the emails and their notes and text messages because they had so much stuff and they couldn't get it over in time, so they were just overburdened. And then Lindsay stated that he would confess a motion that mimics Rule 16 requirements or any relevant statutory authority. The court ordered the people to produce all mandated and other discovery by June 2nd, 2021. Proof evident, presumption great, and preliminary hearing was set for August 9th, 2021. On August 3rd, 2021, Chief Judge Morphew entered further orders related to D6 and D13, consistent with his previous rulings on the record on May 27th, 2021. Order 1 was granted in whole, as it related to D13 and the defendant's request for all emails and text messages between law enforcement officers and all individuals, including prosecutors, contacted and pertaining to the case, the court found the request was too broad and was not required by case law or statute. However, the court ordered that any electronic communications created or received by law enforcement officers related to this case must be disclosed to the defense. And the funny thing is, they didn't really have a lot of. They were supposed to take notes in every meeting. They didn't take any notes. They sent all this stuff off like way late, like almost 8 months later than they were supposed to. Court ordered that any electronic communications created or received by law enforcement officers related to the case must be disclosed to the defense. They are material to the prosecution of the case, or if they contain any evidence that would be in any way favorable to the defense. On June 24th, 2021, the defendant filed a motion for contempt citation. The court and parties held a discovery sanction hearing. The court on the record made the following findings related to discovery materials. Mirror copies of the iPhone. So while that mirror image of the iPhone's delivery to the defendant was past the deadline set by the court and therefore a violation of Rule 16, the court can't find that that was willful misconduct on the part of District Attorney's Office. So basically he's saying because they didn't get it on the deadline, like send the stuff on the deadline, that it was a violation, but they can't, there's no, not like they can't find anything that says that they're doing it on purpose. The spy pen recordings. Court finds a discovery violation there and ordered the remedy of requiring the people to provide that recording, the enhanced version, within 7 days of today's date. On June 2nd, 2021, the people produced a hard drive. A copy of Suzanne Morphew's iCloud account provided to the defense July 12th, so there was a violation of the court's order by about 5 weeks. However, the issue was remedied since it had been provided late, but provided. 2 laptops and a Kindle. Court found it hard to determine whether there's been a violation because there's such a discrepancy in what the attorneys are telling the court. Court findings and conclusions. At this time, I can't really find that it's a pattern. I'm hoping that this is just a result of an enormous amount of information that had to be disclosed within those few weeks, and not a situation whereas new evidence is being generated, new reports being generated, that there's a delay in providing those to the defense. The court also finds that there are violations here. The court also notes, I'm glad that these discovery issues have been brought to my attention because if this does appear to be a pattern, my response might be different going forward. If this becomes a pattern, my response as far as sanctions might be different. I say that in the context of Mr. Morphew being held without bond, which raises the stakes significantly, in my opinion. So I guess he's saying that if they continue on this pattern, which there's really not that much time, so I don't know if there is still a lot of stuff they have to hand over, but if the pattern continues, he is considering, I guess, holding Mr. Morphew without bond. Thereafter, the people disclosed additional discovery between July 22nd and July 29th, again on July 31st, through August 2nd, the people disclosed the CODIS DNA casework match letters between July 22nd, the Tempe CODIS match letter dated, a Phoenix CODIS match letter. I'm not going to read all the dates. So basically, after all that was said, they handed over a bunch of shit. On December 13th, 2021, the defense conferred with the people regarding discovery issues, including the Range Rover data. On January 2nd, the people disclosed a July 16, 2020 email related to very relevant and very helpful information regarding the Range Rover. It should be noted, however, that it is unclear what the author of the email was referring to or whether, if at all, the information was in fact relevant or helpful. Nonetheless, on February 10th, 2022, the court ordered disclosure of the Range Rover data by February 24th, 2022 on the record. Court orders disclosure not later than 14 days. People will write a flash drive that same afternoon. On March 10th, while the court was considering instant discovery litigation, the court was confronted with more motions alleging discovery violations. Yeah, there's just, it's just every like month, it's just more and more like going back and forth, and they don't have this, and then them handing stuff in, and they don't have this, but I think Barry's defense has done a phenomenal job at showing how unprepared they are, the prosecution is, and I think that's going to be huge in trial, because it's like, how can a jury agree on this man being guilty if CBI and the sheriff's office can't even agree that they had enough evidence to arrest him or that it was a good time? Sometimes I've heard that, I mean, it does commonly happen where they take a while to hand stuff into the court, but I don't believe it ever takes like this long. And I think Barry just has super good lawyers that find every little thing that they do. But sometimes it is a tactic that they do to try and leave the defense very little time to prepare. Like, every time they've handed stuff over to the defense, it's been right before the motions hearing. So if they needed to hand them over something that was going to be discussed in the next motions hearing, they'd hand it over like the day before the hearing, and then they'd have to flip through all the pages and look through as fast as they can. So it's just like, I don't know, part of it feels willful to me, but they testified that it's not, and that they're just overwhelmed, and that like everything is just going wrong, and they're not getting reports till late, this and that. But at the same time, a lot of it's like them not doing their job. Like, they had a canine handler who came and was supposed to, like, the canine was there to track Suzanne's scent. And afterwards, they were like, oh yeah, the defense was like, we never got a report for this. And there's a report. And they were like, what are you talking about? We never got a report from this guy. And they asked the guy, and they were like, did you write up a report? He's like, yeah, I wrote up a report, but they never asked me for it. They never asked me for the report. So how, like, I didn't know they wanted it. So it's kind of like they aren't doing their job. Like, they should have been on top of that and asking if he had a report, or, why haven't you handed it over yet? Or why are you not even asking the guy? Like, it's their job to be on top of that. And they're just not even on top of it. Like, the lead investigator didn't even read the whole arrest affidavit, but he signed off on it. Several of them didn't even read the whole arrest affidavit and signed off on it. So it's just like, there's several reports that they admitted that they had not completely looked over, things like that. Like, why haven't you done that? Like, that's your job. Obviously, the defense is combing through everything with a fine-tooth comb, and then they ask them, and they're like, oh yeah, I didn't even see it. I didn't even know that was there. Oh, I didn't even know that email was there. It must have got deleted. Like, I don't know. But the judge is basically saying that, like, there's definitely a pattern that there is just like them being reckless and unprepared, but he doesn't see it as like them doing it on purpose. So where was it? So
what's better?
Yeah, it's been handled terribly. Like, I think, had they have waited and got their ducks in a row, so they explain it like this, like you once you make an arrest, everything stops, and you have to start focusing on court. You have to have all these reports handed in. You can't talk to him anymore because obviously he's going to get a lawyer. Like, once you make an arrest, everything starts going, and you got to start handing shit over and stuff like that. And if you don't have it all yet, or you're not done the investigation yet, then you're still waiting on these things, and they're deciding. Now, CBI was waiting on all these reports. They didn't have like the tire cast reports. They didn't have a lot of stuff, and they didn't have the DNA stuff, like when they first looked at the DNA. They were waiting for all that stuff, and while they should have got all that stuff, then arrested him, but that's why they were begging them not to do it, but they did it anyway. Like I said, I think Linda Stanley wanted to make a big, show out of it and make her look like, oh, yeah, the DA arrested many here. Like, she wanted to make a big deal out of it, and conveniently, Whistle Bridges was there. What's his name? Or Dateline was there, and Profiling Evil knew about it. Like, how did they all just conveniently know about it? Anyway, so the court further found violations amounted to a pattern and saw fit to impose a sanction to deter future discovery violations and encourage compliance with the court's orders. So because there was a pattern and they kept doing it, so basically the judge is saying, I excluded these 14 expert witnesses because of this pattern. Like, that's the sanction I'm imposing on you. So he basically was answering Linda Stanley's motion. Like, hey, I'm not going to allow these people to testify as experts because that's what I sanctioned you with. So 14 of the 16 experts cannot testify as expert witnesses. They can testify, but they can't testify as experts, which I don't know. I mean, I'm sure that makes a difference to an extent. I don't know. I mean, they can still talk about it, but they can't say they're an expert and they know that this is this or this is that. On March 30th, the case came before the court for a Shrek Brooks hearing related to numerous expert witnesses. I'll take a sip of my drink real quick. During the hearing, the people informed the court and the defense that they just learned of a report authored by Doug Spence, the dog handler and expert witness. The people conceded that the report should have been disclosed and stipulated to not calling him as a witness. Accordingly, the court found a Rule 16 expert disclosure violation as it related to Mr. Doug Spence and excluded him from testifying at the trial and prosecution's case in chief. So basically, he's not. I'm pretty sure that the prosecution said that they don't even want that guy to testify at all. I guess they were mad that he didn't hand in the report, even though it was their job to ask for it. But basically, the judge told them, like, I get that you didn't know this report even existed, but it's your job to stay on top of that and ask about that. Relevant witness testimony. So this is basically like the testimony he used to make his decision. On January, the court heard testimony from Alex Walker. A meeting was convened on September 20th with CBI analyst Caitlin Rogers. She's actually going to be testifying as an expert witness. She's a DNA expert. She swabbed a lot of stuff like cigarette butts, tampons, all like bloody tampons, beer cans, a bunch of stuff. And I guess she's going to be talking about that. And I guess they were planning on using her to talk about the needle sheath. I don't know how that's going to go. The judge this is what the judge said about the needle sheath. He said, the needle sheath is it's pretty much speculation. Like, because you found a needle cap in a dryer does not mean anything. Like, that's like saying we know Barry murdered his wife because there's a knife in the kitchen. And that's what he used because it's in the kitchen. Like, it's just, there's really nothing to prove that that's what he used to kill her. Like, his DNA is not even on it. And they're trying to say that it does because it's an odd place to be, like the convenience of it being there. So I guess they're probably gonna have her talk about that, but he was saying like his DNA on it, like wouldn't that hurt you, like hurt your case anyway, because his DNA is not even on it. And they said no, so I guess they're gonna try and talk about like DNA transfer. I still don't understand how that would work though, because his daughter's DNA is on it. So we'll see. Oh, and they said that the khakis in the dryer, like they were trying to say they were the same khakis that he was wearing on the day that she went missing. But apparently Barry has like several pairs of those khakis, and there was a couple of those pairs even in the truck. So like we have no idea if those were the pants he was wearing that day or if they were another one. Let me see. So they had a meeting where they talked to Caitlin Rogers. The people never disclosed the meeting to the defense or what was discussed. In attendance was Sheriff Speasy, Burt, Detective Burgess, Jeff Lindsay, Mark Holbert, Aaron Pendleton, Jonathan Grusing, Ken Harris, Sarah Graham, and many other investigative personnel. In the meeting, the group of individuals discussed, among other things, who to test next, who to swab, and where the investigation was heading. The individuals were actively trying to determine who the unknown foreign male DNA belonged to at the time. Commander Walker did not take any notes and did not generate a report. Neither did any other law enforcement personnel, including the district attorneys. So, like, the district attorneys who, like, have been around the block and know these things should have been taking notes. Exhibit 10 entered into evidence was an email setting up the meeting and produced by Caitlin Rogers. So basically, the only reason the defense knew about this meeting in the first place was because they found an email talking about it. And this is where I don't get either. They're like, oh, we didn't know we're supposed to take notes and stuff like that. You go to school for this stuff. You know what I mean? Like, even if they don't really work a lot of cases, they should know. I mean, I'm pretty sure a couple of these people worked on the Watts case. Like, they should know that what they need to hand over and what they need to do in cases. It's just kind of ridiculous that they dropped the ball so much. Alex Walker did not think he needed to turn over the email because it was just logistical in nature. It contained scheduling information only. Walker agreed with the defense. Sorry, let me turn my phone on silent. Walker agreed with the defense that the meeting discussed exculpatory information, but no one took notes or generated a report. So basically, he admits that in this meeting, there was lots of information that they talked about that could have been used in favor of the defense, that the defense should have had, but nobody took notes about it. I mean, it's just like, these people they just really dropped the ball. I just have a feeling like, the defense is going to throw this around in court, and it's just not going to sound good. I mean, probably not all these details, but that, that they botched the investigation. Where was it? On August 2nd, Alex Walker had a meeting with Detective Cahill to discuss the DNA CODIS match. No notes were taken, yet Alex Walker conceded the topic of discussion was exculpatory. There were 3 meetings regarding the unknown male DNA and CODIS match. However, no notes were taken in any of the 3, nor were any reports issued. Alex Walker believed he saw the Tempe Phoenix CODIS match information attached to Mr. Cahill's report in August 2021, but the report and attachments were not disclosed to the defense until September 27th, 2021. That's after the preliminary hearing. So basically, they had information that was relevant, that they should have given to the defense. They knew it before the preliminary hearing. Now, if the defense had that information at the time of the preliminary hearing, It's okay, Gladys. Had the defense had that information at the time of their preliminary hearing, they could have said, "Oh well, we have suspects," and they could have asked about the suspects, and they could have dug a little deeper, and the judge may have made a different decision. So, like, this is all like a big fuck up, really. The initial CODIS match letter regarding the 3 CODIS hits from Megan Doogie, I guess, or Douche, was received by law enforcement on May 19th, 2021, and turned over to the defense. Alex Walker testified, however, that he did not know about the CODIS match letter when he drafted the probable cause affidavit. Jeff Lindsay. All right, this is Jeff Lindsay's testimony. Jeff Lindsay was the guy who was a DA on the case and left to go to another town. On January 24th, 2020 or 2022, the court heard testimony from Jeff Lindsay. Mr. Lindsay conceded that he had meetings where he and law enforcement discussed testing other people for DNA samples, including neighbors or law enforcement who may have been on the scene. Defendant's Exhibit 14, admitted as an exhibit, was generated approximately 7 months before authoring the probable cause affidavit. Was a request drafted by CBI Agent Cahill to Laboratory Services of CBI requesting the forensic analysis of numerous items. It further stated that this unknown male profile was submitted to CBI Lab as a result of the fact that there was a submission because additional information to suspect the 2015 Range Rover was used in commission of a criminal offense. So, one of the DNA experts wrote an email to Joe Cahill saying, like, based on what we found in the Range Rover, I think that Suzanne's Range Rover may have been used in a crime or or have something to do with it. Agents involved in the case received a DNA report on August 22, 2021. However, said report was not mentioned at the proof evidence presumption grade and preliminary hearing or provided to the defense until September 7th. Detective Burgess received the May 19th CODIS letter from Megan Doogie. He followed up with an Illinois detective identified in the letter. He was under the impression that the Phoenix and Tempe matches had been followed up on already or were otherwise being handled. So apparently Joe Cahill told people that he was going to handle things, so everyone kind of just let go. And Joe Cahill didn't handle it. So, it all got messed up. This letter came only 14 days after the arrest of Mr. Morphew. Detective Burgess also was under the same impression of Alex Walker that Detective Cahill followed up on it. Agent Cahill told Detective Burgess it was being taken care of. Agent Cahill, he's the special one. He's the one who shot himself in the hand. So they heard his testimony on February 22nd. Now, mind you, this is all stuff that he factored into his decision. That's why he's listing it. The email discussed the arrest warrant in the case. The email specifically critiqued the draft arrest warrant of Barry Morphew, noting that it is missing details. So he said that its missing details lack specificity. I think I said that right. Certain forensic investigation information was missing, and work done to rule out other suspects is missing. So he was talking about in the email, they were talking about the arrest warrant. And he was talking about how the draft of that specific arrest warrant was missing details. It lacked specific things. It lacked forensic investigation information. And there wasn't work done to rule out other suspects. And then in Exhibit 23, Mr. Cahill writes that he reviewed the arrest warrant in its entirety. He didn't, though. I don't know why he wrote. He wrote to somebody that he reviewed it in its entirety. However, at the proof evident presumption grade preliminary hearing, Mr. Cahill told Chief Judge Murphy that he only reviewed the first 19 pages. So he straight up lied and said that he reviewed his whole arrest warrant, which he didn't. Mr. Cahill, as part of the ongoing investigation, reviewed reports related to DNA. Mr. Cahill learned Mr. Morphew's DNA was excluded from various items, including portions of the bike and bike helmet, and agreed that those items and DNA results would have been discussed with the investigative team because these are two critical pieces of evidence. However, at the proof evident presumption rate and preliminary hearing, Mr. Cahill testified that he was unaware whether Mr. Morphew's DNA was excluded. So they knew before the preliminary hearing that his DNA was excluded, and he said that at the preliminary hearing that he was unaware it was excluded. He was further confronted with exhibits demonstrating that he likely knew that information at the time. So there was emails and stuff that showed that he did know, and he totally testified something else. In a communications log, Caitlin Rogers memorialized a conversation with Mr. Cahill. The communication log specifically states that Mr. Cahill thinks the partial match relates to suspects who perpetrated the crime. Mr. Cahill did not remember his conversation with Miss Rogers, so he would defer to her communications log. Yeah. Joe Cahill just happened to not remember anything at this hearing. Like, he just, I don't remember that. I don't remember what we talked about. I don't remember getting that email. I must have been away. As a result of the conversation with Caitlin Rogers, Mr. Cahill submitted a forensic analysis request for both 24-1 DNA found on the rear passenger seat and 27-1 DNA found on the glove box, as demonstrated in Exhibit 14 and 25. Both 24.1 and 27.1 were submitted in Dakota system as shown. During the course of Mr. Cahill's investigation into the potential matches to the unknown male DNA, Detective Bermudez from Tempe, Arizona, sent Detective Burgess for this. Now, this email was forwarded to Mr. Cahill. Information with more specifics about the Arizona unsolved sexual assault case. It contained information about the alleged victim in that case and modus operandi of the suspect. That report, written on February 2nd, was never uploaded to SmartForce by Mr. Cahill. Now, SmartForce is like a database that you upload all the stuff to, and then that's shared with the defense, and it makes sharing information easier. So, Mr. Cahill discussed an August 3rd email attached to the 595 report regarding Mr. Cahill's investigation into the CODIS matches. On August 16, 2021, Mr. Cahill emailed the report to Detective Burgess. The court found numerous instances where the defense impeached Mr. Cahill with prior inconsistent statements. Although Mr. Cahill was aware of the DNA linked to two other cases, he did not discuss it at the preliminary hearing, and the people did not elicit questions related to the report. Report 595, Report 599, Exhibit 35 referenced additional Tempe reports and related attachments and was eventually forwarded to Detective Burgess between August 16th and 23rd. So again, they had all this information and it never got shared to the defense before the preliminary hearing, which is huge because the preliminary hearing is where they decide if it goes to trial or not. And had they had some of this information, it may have been a completely different outcome. March 4th, hearing Joe Cahill's IA file. On March 4th, 2022, the court heard additional testimony from Mr. Walker. Mr. Walker denied knowing Mr. Cahill or CBI's position on deficiencies in the arrest warrant. He did not learn about these claims until after he submitted the probable cause affidavit. On March 4th, the court heard additional testimony from Mr. Cahill. Mr. Cahill explained he thought the case was nowhere near ready for court and that the arrest was premature. Mr. Cahill, Mr. Kirby, and Derek Graham all shared the same belief. Mr. Cahill was aware that Mr. Schaefer talked to Sheriff Speasy regarding their concerns. Both Mr. Camper and Mr. Schaefer expressed concerns to Sheriff Speasy that CBI wanted to wait on the arrest. Mr. Cahill did not believe his concerns about the timing of the arrest were shared with the defense. As to Mr. Cahill's testimony at the PEPG and preliminary hearing, Mr. Cahill was told that District Attorney Linda Stanley wanted him off the case, but he was not giving any further specifics other than his general conduct. During cross-examination, Mr. Cahill noted he did not share his concerns with Commander Walker. The arrest warrant affiant regarding the arrest being the worst decision you can make right now. Mr. Cahill conceded his concerns were more procedural in nature and not about probable cause to arrest Mr. Morphew. Further, Mr. Cahill did not even express his concerns about the timing of the arrest to Commander Walker, even though he knew Commander Walker was working on the probable cause affidavit. During redirect examination, however, Mr. Cahill noted he expressed to Commander Walker that the draft affidavit lacked detail and specificity in multiple areas. Mr. Cahill further explained that he did not support the arrest of Barry Morphew based on the state of which that he felt things were at the time. Discussing his position of the case at the time was not in a position to be filed and ultimately to receive a conviction. Derek Graham also thought the arrest was premature in nature because he believed more evidence testing needed to be done, but not limited to the unknown male DNA. Mr. Graham expressed that he was concerned about the timing and discussed the unknown male DNA that needed additional testing. While Mr. Cahill expressed concerns to Mr. Graham, he never used the language that was contained in the internal affairs file. "Quote unquote, worst decision ever." Chris Schaefer, Deputy Director Chris Schaefer. On March 4th, the court heard testimony from Chris Schaefer, Director of Investigation at CBI. Mr. Schaefer made a phone call to Sheriff Speasy and told him he didn't agree with it, the decision to arrest Mr. Morphew, basically that he didn't think the timing was right. To the best of Mr. Schaefer's knowledge, this incident was the first time in his career that he ever called a sheriff about holding off on the decision to arrest an individual. At one point, Mr. Schaefer had a conversation with Mr. Holbert regarding Mr. Cahill's preliminary hearing testimony. He also had a conversation with Mr. Walker about Cahill's testimony. He ultimately made the decision to have Mr. Cahill removed from the case and transferred to the marijuana unit. So Kirby Lewis now is in charge of the major crimes unit at the Denver office of CBI. He agreed that probable cause existed, but the timing might not be the best. He voiced concerns to Mr. Schaefer. He never remembered Mr. Cahill using specific language such as the worst decision you can make or premature. As to Mr. Cahill's testimony at the preliminary hearing, Mr. Lewis remembered having a conversation with Ms. Stanley after hearing concerns from Mr. Schaefer. Ms. Stanley articulated to Mr. Lewis that they no longer wanted Mr. Cahill on the case based on primarily only on his testimony at the preliminary hearing related to CODIS. Ultimately, a decision was made between Ms. Stanley and Schaefer to take Mr. Cahill off the case. Mr. Lewis had no knowledge that Mr. Cahill was in the process of being transferred to the marijuana unit. John Camper is a CBI director. Director Camper had a phone call with Sheriff Speasy after Mr. Schaefer called Speasy first. Camper recalled a definite feeling that there would be a benefit in waiting to arrest Mr. Morphew. So they both called the sheriff and were like, "Hey, man, don't do this, please." Linda Stanley, they heard from her. Ms. Stanley was never aware of CBI's concerns with Mr. Morphew's premature arrest. Ms. Stanley also noted she was disappointed in Mr. Cahill's testimony at the prelim. Specifically, Mr. Cahill, when he got to the stand, answered them questions differently than he had been prepped by Mr. Holbert. Ms. Stanley, Mr. Holbert, and Mr. Lindsay later expressed concerns to Mr. Schaefer and their disappointment. And John Speasy, or however we say it, he's the sheriff who made the decision to arrest Barry. He says he went forward with Mr. Morphew's arrest due to public safety concerns. This is kind of wrong because everyone else said that they believed the sheriff went after Barry because he was afraid that Barry was a flight risk. But then, technically, at court, when they asked him, "Do you think Barry was a flight risk?" he was like, "Oh no, we would know where he is." So he wasn't really worried that Barry was a flight risk. So I don't know why it says that, but planning collision of the law. This is a lot. My God. All right, I'm gonna try and break it down a little shorter. So, all right. So, the affidavit was devoid of any discussion of the fact that foreign male DNA not belonging to Mr. Morphew was found all over the crime scene. So basically, they failed to mention that in the arrest affidavit. On the bike helmet, bike seat, bike brakes, glove box of her car, and rear seat of her car. So they're all the spots where unknown male DNA were found. Now, I don't know if they were able to, like, figure out some of that belonged to the officers or not, but Barry's DNA wasn't on any of those things, and unknown male DNA was. According to the author of the affidavit, Alex Walker did not know about the CODIS match letter when he drafted the probable cause affidavit. Commander Walker was told that Agent Cahill, with 100% sincerity, told these guys that this is nothing, it's been taken care of. Additionally, Commander Walker was under the belief that Agent Cahill put that to rest, and it was done. Walker received the CODIS match letter on May 19, 2021, 12 days after he penned his probable cause affidavit in support of the arrest of Mr. Morphew. In the instant case, the defendant sat in jail for 5 months on a no bond hold prior to receiving the preliminary hearing on August 9th, 10th, and 23rd and 24th. The judge who found probable cause and set a no bond hold was not told that the unknown foreign male DNA was found on various items at the crime scene or in the alleged victim's car at the time of assigning the warrant for Mr. Morphew's arrest. The judge had known at the time of reviewing the arrest warrant about foreign unknown male DNA and CODIS matches to out-of-state cases. He may not have required Mr. Morphew to sit in jail for 5 months pending the preliminary hearing. On September 17th, 2021, the court issued its ruling finding probable cause. The court, however, did not find the proof evident presumption great that Mr. Morphew committed first-degree murder. The court specifically found unknown male DNA profile is partially significant because while it doesn't prove a stranger abduction theory, it at least supports it. It is important to note that Judge Murphy did not learn about the foreign DNA CODIS matches in the arrest affidavit or through the people's illicit testimony at the preliminary hearing. Over 4 days of testimony, the people did not discuss the CODIS matches throughout their case, and Chief Judge Murphy learned about the evidence because the defense presented it by calling and examining Agent Cahill. Shortly after his testimony, the district attorney contacted CBI to express their displeasure with Mr. Cahill's testimony. Pattern of violations. It is clear to this court there is a pattern of discovery violations, in this case attributable to the people. Black's Law Dictionary defines a pattern as a mode of behaviors or series of acts that are recognizably consistent. The people's first discovery and disclosure-related violations occurred on July 2nd, 2021, while Chief Judge Murphy was still assigned to the case. These violations continue and are going as recent as March 30th, 2022, less than 1 month before trial is set to begin. The court found another Rule 16 violation related to an expert report of Doug Spence, March 30th, 2022, generally. Over the last 8 months and over multiple days of hearings, the court has witnessed a pattern of disregard by the people towards its Rule 16 obligations. Court's case management order, note, and subsequent court disclosure-related orders made on record. This court has repeatedly noted it does not, in any way, condone the people's behavior. The behavior has, in the court's eyes, has been recognizably consistent. While the court, for reasons stated below, does not find this pattern is willful based on the record, the court does find the pattern to be negligent, bordering on reckless. So he's basically saying they're teetering on being completely reckless. Which I really hope the defense uses that exact sentence when we're talking about jury. I know I'm of the unpopular opinion that Barry might be innocent, but It's more so that I'm just so bothered by how they handled this case. I think that like fuels me even more, just because I just feel like every American should have their rights to like a fair trial, and they're just totally screwing this up, and I don't know, it bothers me. CODIS matches, like I've talked so much about. First, the court will start with the most obvious egregious violation in the court's view, the CODIS matches. These types of materials, as noted by Chief Judge Murphy during his ruling on bond, September 2021, lend themselves to an alternate suspect theory of the case. Therefore, materials clearly fall within the people's rule obligation as material or information within his or her possession or control, which tends to negate the guilt of the accused as to the offense charged, or would tend to reduce the punishment. Therefore, Chief Judge Murphy did not find the proof evident and presumption great in September 2021. Basically, if you don't know what that means, it means that like they really don't have much, but he has to go in the favor of the prosecution, so he's gonna let them go forward with it. But he's gonna give Barry bond. Chief Judge Murphy did not find. Oh wait, I just said that. Based in part the DNA evidence and testimony discussed by Mr. Cahill. Yet we know law enforcement was well aware of this information for months prior to seeking Mr. Morphy's arrest. The lead detective categorized this evidence as critical pieces of information that would have been discussed with the investigative team. And it communications like Caitlin Rogers memorialized. All right, I read all that. That she had a conversation. That's how they found out. The court finds articulable prejudice suffered by the defense because of the people's failure to disclose some of this material. To illustrate how the defense had all this information surrounding the CODIS matches and related. Bye, Kainas. You're welcome. The court finds articulable prejudice suffered by the defense because of the people's failure to disclose some of the material. To illustrate how the defense had all the information surrounding the CODIS matches and related investigation, they may have decided to call witnesses or experts to negate any probable cause findings. Also, preliminary hearing, Mr. Cahill, one of the lead detectives on the case, testified that he only reviewed 19 pages of the arrest affidavit, yet subsequent disclosures indicate he had reviewed it in its entirety, and even offered specific critiques to the affiant. Those untimely disclosures could have been used to impeach his testimony. Some of the reports related to CODIS matches were in people's constructive possession as early as October 2020, yet not timely turned over. The court finds that people failed to put in place a system to preserve emails as ordered by Judge Murphy. Whatever the process people put in place was clearly ineffective, as the witnesses attested on January 24th and 25th and February 1st that they did not understand the order. Commander Walker, discussing the fact he did not understand the order issued by Chief Judge Murphy, requires the prosecuting attorney shall ensure like tongue twister, sorry, shall ensure that a flow of information is maintained between the various investigative personnel and his or her office sufficient to replace within his or her possession or control all material and information relevant to the accused in the offense charge. The court finds people failed to perform their mandatory obligations. The people argued at one point to this court that the information withheld pertained to ongoing investigation and it was not discoverable information. The court wholeheartedly disagrees with this sentiment. Rule 16 is titled Discovery and Procedure Before Trial. This title embraces the sentiment that discovery in a pending case includes ongoing investigations, testing, etc. The ongoing investigation produces information, reports, etc. that tends to negate the guilt of the accused. It must be disclosed. It is even more serious in situations such as this case where the defendant was held on no bond, hold pending the preliminary hearing. The defendant was held on a no bond hold from May through September. In this case, information from the numerous meetings between law enforcement and district attorneys with CBI, DNA analysts concerning the CODIS matches should have been reduced to writing and disclosed to the defense. The prosecution cannot circumvent an obligation to disclose exculpatory information by deliberately avoiding taking notes, or reducing statements to writing. Even law enforcement witnesses concede this information may be material or have exculpatory value. Commander Walker agreeing that unknown male DNA profile linking to potential lead with unsolved sexual assault cases would be favorable to the defense. So, what did I want to go over? Oh, it's huge because they even had this information before they wrote up the arrest affidavit. And had that information would have been known then, Barry may not have sat in jail for all that time. So, the CODIS matches were discoverable materials. Also, any steps taken to rule out the possible source of foreign male DNA is exculpatory information to the accused in a pending criminal prosecution and therefore must be turned over. Court finds that these meetings regarding DNA discuss exculpatory information and information favorable to the accused during the pendency of the criminal prosecution. Therefore, it was incumbent upon the law enforcement to reduce said information to writing and disclose it to the defense. The court finds that people's failure to disclose the unknown foreign male DNA and investigative steps being taken in the summer of 2021 prior to, during, and after the preliminary hearing constitutes a violation of Rule 16. Basically, this paragraph is just what I said about the affidavit, that they should have, they should have reviewed the affidavit before they signed it, or said that they did and they didn't. And where to say? He reviewed the affidavit in its entirety and noted the affidavit lacks detail and specificity, in particular regarding allegations, suspicions, evidence of their possible involved people, and the investigative steps and results. But even so, there is no requirement that the invite include all information and discovery in support of an arrest warrant, and the defense is not challenging the validity of the warrant itself, arguing it lacked probable cause. Rather, the defense contends that the foregoing omission should have been disclosed through the discovery process shortly after Mr. Morphew's arrest. As soon as Barry was arrested, they should have started sending this stuff over, and they could have had the information, they could have filed a motion, they could have got Barry bond. March 10th, expert disclosures. So this will talk about the last hearing with the expert witnesses. On March 10th, 2022, this court found numerous violations of Rule 16 in its case management orders as it relates to the people's expert disclosures. The court specifically found exclusion was appropriate because there was a pattern of discovery violations. The court, in issuing its oral ruling, noted Judge Murphy's previous Rule 16 findings and violations of this case management orders in July 2021. At a separate hearing, the defense asked the court to exclude all of the people's experts because they missed the expert disclosure deadline of February 14th, 2022. The people conceded at the hearing that they missed the February 14th disclosure deadline while arguing the Rule 16 deadline of 35 days before trial, somehow usurped Chief Judge Murphy's case management authority and rendered the CMO superfluous. The people conceded that their expert disclosures did not comply with Rule 16 or the court's CMO. On February 24, 2022, notwithstanding the violation, the court granted the people's request for an extension up to and including February 28th to comply with their expert disclosure obligations. So they had to hand stuff in for the experts. They even gave them an extension to hand stuff in. The court denied the defense's motions to strike. In the same order, the court warned the people, however, of two things. One, the court in no way condones the people's behavior, and two, it will not entertain any further extensions to the people's expert disclosure deadline. Then, on February 28th, the people filed P44, People's Superseding Endorsement of expert witnesses. The defendant subsequently filed his supplements to his original motion to strike. The defense asked the court again exclude the people's expert witnesses due to their failure to make expert disclosures by the February 28th deadline. So they were supposed to hand in all the information about their expert witnesses to the defense by that date, even after an extension, and they didn't. On March 10th, the court addressed defendant's motion to exclude. After conducting a hearing, the court found the people missed the extended deadline of February 28th for numerous expert witnesses. The court also found there was a pattern of discovery violations and imposed a sanction to deter future violations. The court prohibited the people from calling those experts whose reports and opinions were not turned over to the defense by February 28th deadline. However, the court noted some of those witnesses may still be called in a lay capacity, which means they can still come and talk about it, but they can't be expert witnesses. Other experts were permitted to provide expert testimony, but would be restricted to the four corners of their reports or summaries. So this is the latest hearing, the Brooks hearing. During that hearing, the court found another discovery violation as it relates to Doug Spence, the canine handler. Okay. So this is about the canine handler. The guy brought his dog, Roscoe, to look for the scent. The response from the people presented that Roscoe never alerted to the scent of Miss Morphew. The people opined that because Roscoe never picked up the scent, it supported the people's theory that the bike crash was staged. Miss Morphew was never there, rather another individual placed her bike down the ravine to make it appear like a crash. On the day of the motion hearing, however, the people learned this expert had produced a report, but it was not turned over. Consistent with their obligations and continuing duty to disclose pursuant to Rule 16, the people acknowledged the undisclosed report and stated that they would not be calling the witness. The court excluded the witness based on the people's stipulation. This finding, yet again, supports the pattern of discovery violations by the people. Although Spence would not be called, the court permitted the defense at the hearing to call the witness to determine what information he had not been disclosed, and notably whether, if at all, was exculpatory. Contrary to people's written response asserting that Roscoe never picked up the scent of Miss Morphew, Doug Spence testified that Roscoe did get on scent near the South Arkansas River. Roscoe pulled him down the stream, but lost Miss Morphew's scent at a lock. The court admitted body camera evidence corroborating his testimony. Indeed, the defense played body camera footage of other officers describing Roscoe picking up a scent but then losing it. Mr. Spence was shown the video and agreed with the statements being made as consistent with his findings. Additionally, the people represented in their response that Roscoe kept trying to go in the direction of the Morphew home but could not get there due to the creek. This was false based on the testimony and evidence presented at the hearing. Indeed, Mr. Spence unequivocally testified that Roscoe picked up a scent across the creek or in the creek. He would have pulled him right into the creek and even crossed the creek if necessary. According to Doug Spence, his dog did not go in the creek because it did not alert to a scent of Miss Morphew in that direction or vicinity. Roscoe simply lost the scent. Oh, I need a drink. The defense also showed Mr. Spence, defendant's Exhibit C.
Literally can't find place anywhere.
The report of sergeant. Sorry, I'm making so much noise behind me. It's distracting. The report of Sergeant William Plackner. Sergeant Plackner summarized Mr. Spence's findings in his report. The people also provided the defense a summary of what they anticipated Mr. Spence would testify, which was consistent with Plackner's report and their representations in response. Mr. Spence, however, stated portions of Sergeant Plackner's report were false. Specifically, Mr. Spence discussed the portion of Sergeant Plackner's report that states, after a short distance, his dog was attracted to the water in the area. In his opinion, there was a possible track leading downstream between South Fork of Arkansas and County Road 225 before it crosses the bridge off Highway 50. Mr. Spence unequivocally denied that the dog was attracted to the water or the direction of the Morphew home. Based on the testimony, the court finds Mr. Spence is in possession of information favorable to the accused. It is abundantly clear that the people failed to consult with Mr. Spence, an endorsed expert, prior to making their expert disclosures, and even prior to the Brooks hearing on March 30th, 2022. As illustrated by what transpired on March 30th, 2022, this is not the best practice. People's expert disclosure contained inaccurate statements authored by Sergeant Plackner and the district attorney, who in turn drew additional inferences based upon statements that were never correct in the first place. Mr. Spence's testimony is potentially exculpatory. At a minimum, it does not lend support to the people's theory that Mr. Morphew was never there and that Mr. Morphew staged a crash scene. According to Mr. Spence, Roscoe picked up Mrs. Morphew's scent at the scene, which I find really interesting because when Lauren Scharf did a video, she made a big deal highlighting that there was never a scent picked up, but the judge himself was saying right here that the dog did pick up on Suzanne's scent. So I don't know why Lauren Scharf said that. But while the court did not find the failure to disclose Spence's report willful, it did characterize the failure to do so as sloppy and reckless. In this instance, it implicated exculpatory information. The court found and still finds the proper remedy is exclusion of the witness, but this violation bolsters the pattern of discovery violations in the case. This is also strikingly similar to litigation surrounding the motion to sever the possession of a dangerous weapon count. All right, so motion to sever. On February 24th, 2022, the court held a hearing for motion to sever. District Attorney Dan Edwards stated in his response that the possession of the short rifle is one method that the defendant may have used in the murder, and darts found at the crime scene can be shot from the dangerous weapon. So they're basically saying that he could have used a different gun to shoot the tranquilizer darts. At the hearing, District Attorney Weiner handled oral argument and stated that the dangerous weapon at issue could have been used to fire a tranquilizer, and it was incapable. Weapon at issue could not have been used to fire a tranquilizer, as it was incapable of firing such dart. This was news to both the defense and the court. Understandably surprised, the court inquired about the representations in the pleading, objecting to the motion and advancing a theory that the dangerous weapon could have been used in the shooting a tranquilizer dart. In response, Mr. Weiner indicated that he learned from law enforcement that the weapon was not capable of firing a dart. Mr. Weiner ultimately, in part, confessed the motion, and the court severed the illegal possession count. This was the first time the defense became aware that the people no longer sought to introduce evidence that the weapon was capable of firing a dart. So they were going to present that as evidence. Remember, they found that short rifle, and they charged him with like a weapons charge. I guess it wasn't locked up or whatever. Well, they were trying to say that he could have used that rifle to shoot the dart because his actual dart gun was broke. But later, they decided they weren't going to introduce it anymore, and that guy testified and said that it wasn't possible. And the defense had just become aware of that. And akin to the situation with Mr. Spence discussed above, the people made incriminating inferences based upon assumptions and or inaccurate information. So basically, they're just like speculating all this bizarre shit without having like accurate information to back it up. Like they're saying this gun can shoot a dart, and that the dog never picked up on a scent, which it did. So it's just really like even the cap in the dryer, like that cap could have been in there forever. Finding a cap in the dryer, does that mean he used the cap to kill Suzanne? Yeah, I know, it does seem so long ago. Internal affairs. So court finds as it relates to the internal affairs file. So this is the internal affairs doing investigation on Cahill. Instead of the people handing over the internal affairs file, which is favorable to the defense had to subpoena to get the file. On January, on the record, the court granted in part and denied in part the people's motion to quash the defendant's SDT. After the court's in-camera review, the court immediately disclosed the file to the parties, citing Rule Brady v. Maryland. The contents of the internal affairs file concerned events occurring between November and December 2021, after the arrest of Mr. Morphew and the preliminary hearing. While it is clear the file contained the personal opinion of Mr. Cahill indicating he thought the arrest was premature, it was ultimately not Mr. Cahill's decision to make. Like, he couldn't make the decision on arresting Barry or not. It was the sheriff's decision. The defense may nonetheless inquire about it during trial. However, this does not amount to a Rule 16 violation. Accordingly, the court finds the people did not commit a discovery violation pursuant to Rule 16 or the court's CMO. Therefore, the court denies any request for sanctions based on the arguments set forth. The Range Rover data. The court finds, as it relates to the Range Rover data, that while the people have been dilatory in providing the data to the defense, the court does not find said material exculpatory at this juncture. Court ordered disclosure of the Range Rover data by February 24th. On February 24th, defense made another request for the Range Rover data. People provided a flash drive that same afternoon. On March 1st, the defense contacted the FBI agent regarding the Range Rover data. The FBI agent indicated he sent the initial data to the FBI case agent on July 23rd, 2021. The people assert the email was sent before the FBI completed the analysis. Yeah, it's insane. These, like, don't they go to school for this stuff? Like, how are they just? It's like they're throwing the case on purpose. Like, who sits in a meeting about important information and takes zero notes? Like, I have to write everything down. You're telling me 12 people sat in that room about important information about this case and none of these motherfuckers wrote a freaking jot down? Nothing? Like, excuse my language, but damn, like 12 people in a very important meeting and nobody wrote down anything while they had a paper and pens right in front of them. It's just insane to me. Like, who are these people? Where was I? Now I lost my place. The underlying issue is a July 16th, 2021 email disclosed to the defense on January 26th. The email states the evidence includes very relevant and helpful information regarding the Range Rover. Both parties dispute the meaning of these terms. Defendant asserts the language indicates evidence that is material or exculpatory. The people, on the other hand, argue this language is not exculpatory or material. While the email stated information is relevant and helpful in and of itself, it does not lead to the conclusion that the use of said language means it is also material or exculpatory. The court cannot conclude that the email, based on the evidence provided, is in violation. Relevant evidence means having any tendency to make the existence of any fact that is consequence to the determination of the action more probable or less probable than it would be without the evidence. An officer simply referring to the data as very relevant does not make it so, nor is the statement itself relevant under Rule 401. Whether or not the Range Rover data is relevant will depend on what information is contained in said data. The court does not find the email itself is in violation of Rule 16 or Chief Judge Murphy's June 2021 order. The actual Range Rover data, on the other hand, does fall under Rule 16 and should have been disclosed. So I guess them not handing over the data on time falls under Rule 16. Indeed, the FBI agent analyzing the data indicated he sent the initial data to the case agent on July 23rd, 2021. While this information should have been disclosed in July of 2021, the defense is now in possession of that data to the best of the court's knowledge and is free to consult with an expert to determine what information is contained in the file. The information may very well be relevant or helpful, but that remains to be seen. Accordingly, any prejudice suffered has now been cured. While the defense argues that it's too late to consult with an expert and extract the data, the court finds the statement conclusory and additionally notes that the defense is not seeking a continuance to consult with an expert. Conclusion. We're almost done. Wherefore, the reasons stated above in the court's discretion, the court concludes as follows. The court finds a continuing pattern by the people of an inability and failure to comply with its Rule 16 obligations, as well as the court case management orders. The court finds the people's actions amount to negligent and arguably reckless disregard for the Rule 16 obligations and duty to abide by court orders. The court does not find, based upon the record, the people's actions amount to willfulness. The defense requests the following sanctions: dismiss the case, reduce the charges, set a reasonable bond, and reimbursement of attorney's fees and costs for time and expense incurred. The court finds the following as it relates to a request for sanctions. March 10th, the court sanctioned the people for their continued violations related to expert disclosures and excluded numerous experts as a result. The court excluded the following prosecution experts: Megan Douche, I don't know what she did, Andrew McDermott, Kevin Hoyland, exclude the witnesses as expert witnesses.
My aim locked.
2, James Stevens, Kenneth Hicks, Alex Walker, Andy Rorick, Jonathan Grusing, Derek Graham, Ken Harris, not permitted to provide expert testimony, but free to provide lay opinions. So all those investigators can't testify as experts. They can just give their opinions. Caitlin Rogers may provide expert testimony, but restrict it to the four corners of her current report. So I guess she can't provide testimony about other stuff, just her reports. On March 30th, 2022, the court excluded another preferred expert witness, Mr. Doug Spence, albeit based upon the stipulation of the people. These sanctions on March 10th and 30th effectively excluded 11 out of 16 of the people's endorsed expert witnesses. 3 additional experts were excluded on other grounds. So 14 out of 16 experts in total. So they excluded 11 out of 16, and then 3 more were excluded for the prosecution just not handing shit in on time. The court finds the exclusions of these witnesses amounts to a significant sanction, but one that was warranted based on the record. Considering the witnesses, this court has already excluded as a sanction for the people's discovery violation. The court does not find a reduction of the charges to be an appropriate remedy. The court is also mindful that the defense is now... I don't know what this means. I thought this was interesting. The court is also mindful that defense is now in possession of exculpatory information, which cures much of the prejudice. I don't get what they mean by that. Like, that he agrees with it, or they have something that we don't know about it. But, because the court did not find willfulness on the part of the people, dismissal of the case is beyond this court's discretion. So, like, because he didn't find any proof of them doing it purposely to, like, mess up the case, or, like, he can't make that decision unless they're doing it willfully. Because the court does not find reducing Mr. Morphew's bond as an appropriate sanction. Regarding the IA file is denied relating to any request for sanctions, as the people did not have constructive possession of the file. Regarding the Range Rover data is denied, but the court does find the people failed, yet again, to comply with the court's disclosure deadline related to the data. The remaining expert witnesses at this time are Caitlin Rogers, subject to limitations, and Christine Lucero, subject to a continued Shrek hearing on April 29th at 9 a.m. So on April 28th, they're going to start picking jurors. And then between them picking jurors, they're going to have another Shrek hearing, where they're going to discuss, I think Christine, let me look at my notes. I'll tell you right now. I think Christine is the nurse. I have like these sticky notes all over my screen with notes from like 80 different cases. They're just all over my computer screen. Hold on. I'll find it. Aha. All right. I'll explain who these people are real quick so you have an idea. All right, so this is a little update from the last thing. Grant Grosgabar, he's a new DA for the prosecution. They said he's like a little bit fiery, so I guess that's good for them. All right. Caitlin Rogers is she does the DNA. They talked about her. Okay, Dr. Lisa Wolf was a vet who knew a lot about the tranquilizers and how it affected animals. Lisa Wolf can't testify as an expert because while she knows a lot about the tranquilizer, like how it affects animals, because she's a vet, she even has a patent on it. That's how much she knows about the tranquilizer. She knows zilch about how it affects humans or about how it, like, there's no studies of how this particular thing affects humans and how it affects animals. So really, she can't come and expertly testify and say she knows that this thing could kill Suzanne because there's really no studies on it. She only knows how it affects animals. But the DA said, "Oh no. Well, Suzanne would be the same size as like a deer, so it could definitely kill her." But the judge said no. Like, first off, there's no data, or like we don't know anything about it. And two, just because there's a cap in the dryer, there's no connection on. Like, you can't say, "Oh, I found a cap in a dryer. He must have killed her with a tranquilizer gun." You know what I mean? Like he said, it's like finding a knife in the kitchen and saying, "Oh, a knife must have been the murder weapon because it's in the kitchen." So Kristen Lucero is a forensic nurse. She was supposed to come to the last hearing and testify, but she had a conference she couldn't get out of. She looked at pictures of Barry's arms and speculated what could have happened, but she never examined his arms in person. So the defense basically said, like, well, how could they come to these conclusions without actually examining the person and knowing the person's medical history? And that this woman may be an expert nurse, but she is not an expert at blindly inspecting injuries from photographs. So how could you even make a medical determination? Like, if you were an expert at making a medical determination from photographs, now that would be different, but she's not. And they also said the vet knows, basically what I said. The vet knows how tranquilizer affects animals, not humans. There have been no studies on how it affects humans. Prosecution talked a lot about the materials inside the dryer, trying to say there were shorts in the dryer that belonged to Barry, and they didn't find until 7 days later a sheath they believe came from his pants on the day he killed Suzanne. The defense saying Barry has multiple pairs of those shorts. He even had very similar pants in the dryer that were in the dryer found in his truck. Defense says, how do you not know? Like, how do you know if it was placed in there by the deputy or if it was found in there? And then Barry's DNA was excluded from the needle sheath cap one of the daughters and Alex Walker's DNA was on it. The prosecution said, well, the cap has to be connected. It's out of place. And there is tranquilizer material that is missing. Barry even admitted that he used it recently and threw it away. And then the defense said, well, we don't have a toxicology report, and we don't have a body, so how could we even say that she had tranquilizer material inside of her? And the judge ruled that it's way too speculative to proceed only on a theory that a tranq was used because they found a cap. That's like saying there's a knife in the kitchen, so the knife must be the murder weapon, or there's a gun in the safe, so it must be the gun. The witness can't testify, but they can't testify, but not as an expert, but as evidence. It could still be permitted, so they can still permit the cap, but they can't, she can't testify as an expert. And then the judge said, doesn't Barry's DNA on the needle sheath hurt your theory? And the prosecution said, no, it's the nature of the DNA. They talked a lot about the vet's history with BAM, which is what the tranquilizer is called. And then she even has a patent on it. The BAM had expired, and it was from 2 years ago, which would make sense because Barry probably really didn't use it much because he used to have a deer farm. And he probably used the tranquilizer often when he had the deer farm because he would sell deer or take their antlers off and sell them or whatever, and he had permits to do that. So probably used it a lot when he worked at his deer farm, but now that he was in Colorado, I believe it was legal. So it would make sense that it was from 2 years ago and expired, and then he just brought it with him.
There's another
and then they wanted to know, well, how does that play a part? If it expired, how would it be ineffective? So basically, and then there was no study on BAM on humans or the differences between animal and human. They said the gun was not operable, how it was found in the safe, no syringes found in the house. Only one syringe was found but never tested. I think maybe in the truck. They said this isn't I think the prosecution said this isn't speculation, it's reasonable inference. No blood in the house, but Barry admitted he had BAM and used it recently. And they said what the defense says go way beyond Brooks. I don't know what Brooks is. I think it's like a legal term. An animal similar in weight to a human. If an animal can be killed by it, so can a human. So they're excluding Wolf as an expert. And the nurse, they don't know if they're excluding her yet. They'll find that out at the next Shrek hearing on the 29th, which will be already after the trial had started. So, setting and the selection of bond is reasonably ensure the appearance of the person as required to protect the safety of any person or the community, taking into consideration the individual characteristics of each person in custody, including the person's financial condition. Judge Murphy made findings and considered the criteria outlined and set bond at $500,000 cash only. The people originally requested bond at $10 million cash only. Mr. Morphew requested bond be set at $50,000 cash bond. As to the motivation behind the removing Agent Cahill from the case, the court does not find a discovery violation. However, the defense is free to inquire about it at trial before the jury. So, they were saying, so basically, to break that down real quick, they were saying that they had already planned to be moving Agent Cahill to the marijuana crimes unit, but it does seem kind of shady that they removed him when they did. So he's saying, as to the motivation behind removing Agent Cahill from the case, the court doesn't find a discovery violation since they said they were already considering it, but the defense is free to ask about it during the trial in front of the jury. The court concludes. Oh, God, I need a drink. Hold on, I keep coughing. The court concludes additional sanctions are not appropriate at this time. However, the order will serve as the baseline for future orders related to discovery violations. The case is set for trial to begin on April 28th, 2022. So ordered this Friday, April 8th, 2022 by the court, Ramsey Lama. And that's it. So hopefully I broke it down in an easy way, but it's also complicated, so it's kind of hard to. But I mean, I kind of expected this to happen because it's really not common to
Fucking rat.
dismiss a case. Like, that's a really extreme sanction, and just like, I didn't think that they would. But I mean, I think like nobody, if it could have got dismissed, that would have been great, but it probably would have been dismissed. Dismissed, what is it, with or without prejudice? I forget which one, but it would probably be dismissed so that they would be able to retry him later. So this might just honestly be better for him anyway, because had they dismissed it and they were able to retry him later, they could dig up more information. But right now, they're in shambles, so, go to court now and get it over with. He'll probably end up walking free, but maybe not, because I feel like the jury pool is probably super tainted by now. But I think it's a good possibility that he will walk free, though, just because all the stuff, like, there's really no concrete evidence that there a murder even occurred, and the defense wants them to play all like 40 hours of interviews between Barry and the investigators, and I think they want to do that to kind of portray how the investigators questioned him. Like, I think a lot of the reason why Barry seems suspicious is because of what they said in the affidavit, that he said that he turned left and he did this. But I feel like maybe some of the context of the questions, if the jury's actually heard the context of the questions they ask him, they might have a different opinion on like what he said. You know what I mean? Like, they could have said, "Oh, well, if you had turned left." Like, they could have asked, "Did you turn left when you were leaving Plymouth Path?" And he could have said no. And they said, "Oh, well, if you turned left, why would you have turned left?" And then, he could have said, "Oh, well, I probably saw some milk." You know what I mean? So it's all in the nature of the questions. And I think that's why the defense wants them to listen to all 40 hours of interviews, which isn't going to freaking suck, I'm sure. That's probably going to be so boring. Yeah. That's better. The date will change also. Yeah, I mean, it could change if there's like other stuff going on, but that's gonna be really shitty to be a juror and have to sit through 40 hours of interviews. It's gonna take forever. I don't even know if they're gonna have time for that. I mean, I guess they would, because they requested that they do that, so I guess they have that planned in the time frame. But it sucks that we can't watch this, because I'd love to see. I really want to see Jeff Libbler be cross-examined. Like, maybe I can order the court transcripts later, but it's so expensive. It's probably like $300 for like 20 pages. But maybe I could just find Jeff Libbler's testimony, or testifying, or cross-examination, and print it out. I really want to hear that. I want to hear what they ask the girls and what the girls say. I think it's interesting that they tried to say, like Suzanne said to Sheila, that Macy told her to get a restraining order against Barry, but apparently Macy completely denies that and says that never happened. Oh, the audio would probably be cheaper, yeah. Well, I remember looking into the court transcripts for the preliminary hearing, and it was a lot of money for like all of the days. It amounted to almost like $1,000. It was insane because it had 4 days, I guess. So like, I think like 1 day's worth of stuff was like almost $300. Because I remember, what's her name got the transcripts, which I ended up just reading them through there on mute because I don't like her voice. I know, Plunder. That's her name. I don't know why. I just don't like her voice. No offense, Plunder, but I did read all the trend, and I think it makes a huge difference. Douglas County? I don't know. Let me see. Or it's Chaffee County, I'm pretty sure. Well, no. They're Fremont County. They're having the trial in Fremont County. So I guess you would get it from the Fremont County courts. It might be different there because they have the prelim at Chaffee, so it could be cheaper there. But yeah, but I think reading the transcripts makes a huge difference because, like, for instance, like when Lauren Scharf was recording about the dog, like the canine handler, like she stressed so much that this dog didn't pick up on a scent. And the judge just said it in his thing that it was clear that the judge that it was clear that the judge or that the dog picked up a scent. So like I just feel I like hearing from Ashley Franco, but I feel like she hasn't been as detailed lately because I feel like she's the most unbiased. But like from what all right, how can I explain this? When I got all the updates on Twitter from the preliminary hearing, and then I read the transcripts, like there was so much information in the transcripts that you would have never heard. I mean, even just like little stuff that like Suzanne lied about Valentine's Day and that she showed up unannounced at Jeff's hotel. Like there were so many things they never even mentioned that I was like, wow, I would have like never known all this. So I mean that's really besides getting updates from people in the court, that's really the only other way to get the information. But we can try when it comes down to it. Sucks that it's not gonna be televised, but I get why they've kept it quiet. All right, guys. I'm getting tired, and I'm probably gonna end up gaming with Dave playing Ghost Hunting games. So I'm gonna hop off now. He's gonna probably stream at 9. But thank you guys for coming. I just had some surgery. Oh wait, hold on. Let me look it up real quick. That's what I meant to do before I go. Hold on. Screw. Wait, why did it do that?
Okay, coming up the steps right now. Coming up the steps right now.
I don't even know where I'd find this right now. Sure. So it's help form. Access to public records. Oh.
I can't go fucking shop to save my legs.
I found it on Chaffee County. Why is it? I found it on Chaffee County, like the price and the form. It's like you get it. I think it was like like 50 cents a page or some shit, and like it was like so many pages. It was just it came to a lot of money.
And they're literally looking for me right now. They literally just
I don't know. I'll have to look more into it. Thank you for coming, Sunflower. Alright. Well, good night, guys. Hopefully, I broke that down clearly. Oh, yeah, I can hear him. Oh my gosh, it's terrible. And then when I'm talking and I'm like reading and he starts shouting, I like start focusing on what he's saying and I get sidetracked and like I'll keep I keep like having to stop because I keep hearing him and it drives me crazy. And especially when he starts like cursing and stuff. I'm like, oh my god, I gotta start talking louder. But yeah, he's getting all worked up now. So and my mic picks up everything. I mean, it's a great mic, but it literally just picks up everything. All right, I'm really going now. Good night, guys. Thank you for coming. Bye bye.
I have the least amount of kills.